Subscribe to get contents via mail. Purchase shorthand journals and more.
Srimati Mamuni Goala, PW10, stated that she did not see the incident except finding the dead body of the deceased. PW12 is the investigating officer who investigated into the matter. PW12 is another investigating officer who submitted the charge sheet. The said two investigating officers had no personal knowledge about the incident. From the above discussed evidence rendered by the prosecution witnesses, more particularly PW1, PW3 to PW10, no incriminating material could be found against the appellant. The learned sessions judge, while holding the appellant guilty, came to the findings that the appellant stated before the police (PW12) that he had murdered the deceased and that the appellant killed the deceased taking revenge for the murder of his mother by the deceased's son, namely Bijoy. Statement page. Confession alleged to be made before the investigating officer by an accused cannot be accepted as evidence except to the disclosure leading to the discovery of fact. Therefore, the confession, if any, made by an accused before the police is hid by the provision of sections 25 and 26 of the Indian Evidence Act. In our considered opinion, the learned sessions judge committed error by accepting the confession made by the appellant before PW11 as legal evidence. There is no dispute that the mother of the appellant died due to homicidal death. The son of the deceased, who is appellant in criminal appeal number 22(J)/2004, has also been convicted by the learned trial judge on the charge of killing the mother of the appellant. Similarly, the present appellant has also been convicted by the trial court on the charge of killing the mother of the appellant of criminal appeal number 22(J)/2004. In view of the said cross murders, though suspicion can be raised indicating that the present appellant, out of grudge and in order to take revenge of killing his mother, had killed the mother of the appellant of criminal appeal number 22(J)/2004, but suspicion, howsoever high, cannot be substitute of legal and substantive evidence. In order to hold a person guilty of a charge, prosecution is required to establish the case beyond all reasonable doubt by adducing cogent and substantive evidence. Failure to do so would result in acquittal of the accused person on benefit of doubt. In view of the discussion in the present case, the prosecution has failed to establish beyond all reasonable doubt that the appellant had inflicted the fatal blows on the deceased. Therefore, we find sufficient merit in the appeal requiring interference. Accordingly, the appeal is allowed. The impugned conviction and sentence is set aside. The appellant be set at liberty forthwith. In appreciation of the assistance rendered by the learned amicus curiae, we direct payment of ₹5,000 in his favour by the Assam State Legal Services Authority as his remuneration. Return the lower court records.